In this session, we'll discuss how to sue judges, magistrate, clerks, and commissioners, things you need to know. As always in the child support system, there are officers of the court that are covered by what is called judicial immunity. If you want to sue any of these officers, judges, you have to overcome judicial immunity. Now, in this session, we will review two lawsuits, one of which is done by what's called Mr. Leon Cazole, but the real underlying case is called Parent versus New York, and another one by Bullock. And we will review these to determine the outcomes in terms of when you sue the agency. Now, in order to sue officers of the court and judges, you have to do what is called 42 U.S.C. 1983, and we'll talk more details about that, and you can file a lawsuit either in state or federal court. So what is judicial immunity? Well, there are two types of judicial immunity. There's absolute immunity or qualified immunity. Absolute immunity is where a judge who's been confirmed for life, you cannot remove them or cannot file a lawsuit against them. And qualified immunity have certain criteria. Now, in order to sue an officer of the court, you have only two criteria, and that is, one, they must deprive you of a certain right secured by the Constitution or laws, federal or state, as well as the defendant must be acting under the color of law. Yes, under the color of state law. So here's a short quiz. A bankruptcy judge was created by the Act of 1978 called the Bankruptcy Laws, and a bankruptcy judge is appointed for 14-year terms. So here's the question. Is a bankruptcy judge covered by absolute immunity or qualified immunity? The answer is they're covered by qualified immunity, not absolute immunity, because a bankruptcy judge is not an Article III judge. Talk about what are the techniques you should know if you were to sue judges, magistrates, and clerk in the child support program, and how to protect your rights. As always, we cover our non-lawyer maxim. We're going to get a little bit more details as to the laws itself, and so here's the disclaimer, okay? No state shall convert a liberty into a license or charge a fee thereof, as well as the practice of law cannot be licensed by a state. As we review these cases, preview it as we're going to teach and show you what needs to be done. In other words, we're providing education. So let's start off with first filing a lawsuit. The code 28 U.S. Code 1654, and it reads, in all courts of the United States, parties may plead and conduct their own cases personally or by counsel by following the rules respectively and manage their cases. Yes, you can file your lawsuit without an attorney. Again, this is not an issue of whether you should have an attorney or not have an attorney, but the code allows you to file your own 1983 case. However, the courts cannot force you to use an attorney. The law says that even though it allows for you to have a right to have counsel, the courts cannot force you to have counsel. And that's case law is State versus Penderville, as well as Moore versus State of Michigan. That is, if you were to file a 1983 case, the clerks and the justices cannot tell you, well, you need to have an attorney in order to do that. Again, that is false. We have a video called Your Right to Access the Court and Win Without an Attorney. Feel free to check that one out as well. So let's continue. Title 42 U.S. Code 1983. This is the statute that's used against government officials and judges and clerks to sue them for deprivation of your rights. And the first part of it reads is, every person who's under the color of any statute, ordinance, regulations are subject to the citizens of the United States if you deprive them of your rights. The second piece of the code is, in any lawsuit brought by a plaintiff must prove that she has been deprived of a right secured by the Constitution and the laws.